Hi, everyone. Welcome back to HeirKare with Kathleen and Erik. We are estate planning attorneys with the firm Fowler Baker Shade, and we are here to give you some legal information. Today, we are talking about revocable trusts. Remember, everyone, that this is just information and not advice. We highly recommend that when it's time to start working on these things yourself, that you go find an estate planning attorney in your area to help you do these things. And again, like I said, today we are talking about revocable trusts. We last week talked about last wills and testament, and now we are kicking it up a notch to one more level up on complexity when it comes to estate planning. So, Erik, why don't you take a minute to tell us what a revocable trust is and maybe how that differs from using a will?
Yeah, so a revocable trust is at its base level, it's a contract. It's person A gives a piece of property to person B to hold for the benefit of person C, and lays out rules in that contract for how that's going to be done. Where that differs from a will is going to be that a will is a instructions to somebody to at some point in the future do things with my stuff, and go do that through with a court supervising you doing that process through the probate process. Um, Revocable trust is going to be a step up from that in that it's a contract that covers kind of what to do in various situations, can cover all kinds of different things that we'll talk about in more detail in a few minutes. But it's a sort of vehicle we use to get things out of that probate process into these kind of more detailed situations. Where they do get a little confusing and hard to think about is that they are, we talk about person A, person B, person C. Well, those can all be the same person, at least when we first create these, and they often are. Often it's me creating a trust with me as the trustee holding bit property for the benefit of me. And so those can be a little confusing. But I know, Kathleen, I know you've got a great little visual you use with people to be able to understand
Yes.
that confusion and resolve that. So why don't you kind of explain that for
All
us?
right. So this is my example of a revocable trust, very high tech here. And what you'll notice is that this is see-through, right? And there's no lid on this. And why do I point that out, right? Because as far as the government is concerned, this is a disregarded entity, right? We're talking about a revocable trust. A revocable trust means whoever made the trust can revoke the trust whenever they want. So the government doesn't really care about this, meaning it's not going to impact your taxes. Your income taxes aren't going to change. Your capital gains taxes aren't going to change. None of your taxes are going to change by virtue of using this estate planning tool. As you see, there's no lid on here, right? So when the rain comes, when the wind blows, if something is inside of there, it's going to get wet and cold, right? So why am I saying that? Well, because bad things happen in life, right? We end up with accidents that were found at fault, and we can have creditors from that. We can have creditors from medical expenses. We can have just creditors from life getting expensive, right? So anything that if I set up this trust is mine and it is revocable and I have creditors, there's no protection here for me for my assets in here, right? The creditors can get at any assets that I put in here. So this is revocable and it is not going to give me liability protection. But what it does do is there's a bunch of rules kind of written on this box, right? And it says, okay, well, something were to happen to me and I pass away, I want this all to go to my kids. And you're like, well, there's nothing in the box, right? Okay, so how do we get stuff in the box? Some things we can just put in the box, like personal property, right? Here's a little toy from my son, right? So we can put our personal property in the box via an assignment. We can put our real property in the house or in the box, right? So example here, house keys, right? So I'm going to put those in the box. How do we do that? We retitle property in the name of the trust. We can even take our vehicles and put them in the trust. We can take our bank accounts and put them in the trust, right? Sometimes our money is in an IRA or 401k or 403b or a TSP, the alphabet soup of retirement assets, right? And those are not going to go in the box, but we can point them to the box. So the goal is to have everything in the box or pointed to the box. Why is this our goal? So that we can avoid probate. Because what I've done is I've written the rules on here and everything's in this box or pointed to the box. And when I pass away, the lid goes on the box and things only come out according to the rules I put on the box. So this is my little demonstration of a revocable trust. And then, Erik, maybe you can tell us a little bit about when the lid goes on the box and when this becomes irrevocable. and what the difference between the two is.
Right, absolutely. So when the trust becomes irrevocable is well, typical lawyer answer depends, right? First off, it's you get to decide in the terms of the trust when the lid goes on. And typically for most people, that's when you pass away, or if it's a married couple, once both of you have passed away. Sometimes in a blended family, it might be when one spouse has passed away, we might make a portion irrevocable and leave another section revocable. Um, but overall, for the most part, it's going to be someone dying that has caused us to end up in an irrevocable trust. And what that means is at that point, the only people who ever had the power to make a change to the trust or to say, never mind, I don't want the trust, have all passed away. And so that at that point, there's just nobody has the power anymore to change it. And so what's the terms that were defined by the initial person who created the trust, or the grantor typically is what we call them, they those rules stay in place. Nobody else can change them. Um, and so, for some reasons why we often do that, are we're passing things down to our kids, and the kids might be a minor, and they so at 15, we definitely don't want to hand $1 million to a 15-year-old, right? Or at least not with just complete access to just go spend it how they want to. And so, as loving a way as possible, we're going to put some rules in place for how the 15-year-old can spend the money. Um, Another one's going to be if we have a disabled beneficiary, or disabled child that we're passing things down to. There are very specific ways that we can do that make sure that any government benefits that they have are still safe. But to do that, we have to have very clearly defined rules on when the beneficiary can access the money and how. And often those rules are actually told to us by the government. We don't get a whole lot of say in what they are. We just have to follow the rules as they're given to us. Um, so those are kind of we put that in there, and then once they're there, the beneficiary can't come back and say, "Well, I don't like the rules, so I want the money now. I'm going to change the rules." No, that's not an option. It's irrevocable. It's locked in. We've put the lid on. It's going to be what it's going to be at that point. Um, so that's kind of the big distinction, the big break point for those two. Um, so Kathleen, what are some of the other situations that we do also use these types of trusts besides some of those that our clients often kind of view as the reason why they chose to go the trust route
Yep.
as opposed to just sticking with a simple will? Because trusts are complicated. Trusts are hard. Why do I need a trust?
Right. So sometimes you can get away with just having a basic will or maybe a more sophisticated will. But there's definitely several factors that we look at when we are deciding, hey, when is it appropriate to do that extra work and pay the extra money to do a revocable trust? Right. And Eric, you touched on a couple of those. We've got minor children, beneficiaries who have some type of disability, right? And you touched on this a little bit before also, but if you have a blended family, so we are concerned about when the first spouse passes away, we want to make sure that the deceased spouse's side of the family's share is protected. So that's another common situation. If you have a lot of money, excuse me, and a lot of money is not a set number, right? If you have a minor child or an adult child who can't manage money, right? A lot of money becomes a much smaller number. Or if you have a beneficiary with an addiction, a lot of money is a smaller number. Whereas if you have adult children who are healthy and capable of managing their own affairs, a lot of money could be a whole lot of millions and millions and millions of dollars, right? So that's not a set number. Another situation is if you have a complex asset structure. So maybe you own a bunch of different businesses in different locations, right? Something that's going to just take longer to put through probate if you were to use a will. Another one is if you just own real property, so a land or a house in more than one state. We generally recommend people consider doing trust planning then, because when you have real property in two different states, you're looking at having probate in one state and then at least an ancillary proceeding in another state. Ancillary meaning adjacent to, right? So it wouldn't be a full probate necessarily in the other state, but there would be additional cost and time in pursuing that other probate in the other state. If you are an individual who just doesn't like the government, doesn't want anybody knowing what your stuff is, you don't want to have your documents on file with the court. You're definitely going to be looking at trust planning then to avoid that. And last but not least, some people just don't want to do probate. Maybe they've had a bad experience before. Maybe they've, heard horror stories before. Sometimes people don't want to do probate because they understand that, doing trust planning is going to make it a little easier for their beneficiaries and the trustees to administer their estate, right? Because one way to look at trust planning versus doing a will and testament is that a trust is, in many cases, a cost and labor shifting mechanism, right? So you're going to pay more upfront, you're going to do more work upfront, but then your beneficiaries, they'll still have some work to do, right? But they are going to have less work to do. It's not going to be scrutinized by the court. They'll have a lot more freedom in how they administer the estate, and the timing in which they do that. So those are the
They'll
general.
kind of they'll have more control over the time, right? They'll get to to say, well, what do you mean I have to go ask the court to be able to move the money from that bank account to that bank account? Well, in probate you do,
Yes,
right?
yes,
And so versus a trust, you just move it, and the only limitation is how long does it take to sign the paperwork and get the cash to have the little blips on the computer in the bank system to move.
yeah. So one wanted to go through just the terminology and excuse me, Eric, you hit on this a little bit before, and I'd like us to just revisit so that we make sure everybody understands the terms that we're using here. And at a basic level, we'll start off with this one, which is people see living trust used a lot. I don't like using that term because a living trust just means a trust set up between people who are living, right? That could be revocable or that could be irrevocable. And those are very different instruments used for very different reasons. So I don't really like that term. So if you're ever doing your own research online and they're only referring to something as a living trust and not being more specific and saying revocable or irrevocable, I would suggest not reading that site anymore and find something that is going to speak with more specificity, to the situation. One of the other things I think that is interesting in trust planning is we have a whole lot of names for what we call somebody who sets up a trust. And so if you're reading about this, on your own, Eric, what are some of the things that people call the person who sets up a trust?
Yeah, so it's going to be most common. We use the word grantor in our stuff just because I think it makes it clear to me at least. It's I'm the person who's granting property into this thing, right? But we also see words like trustor, settlor, trust maker, all of those things. To me, they're just some of them are a little bit old timey and everything. I like going with super simple. Okay, what am I doing? I'm granting things to trust. I'm a grantor.
Mhm.
Easy to do, right?
Yep. I was going to ask you about a beneficiary. Who's a beneficiary in there? What does that mean? Is it just one person? Can it be a whole group of people?
So the beneficiary of a trust is going to be the person who is entitled to get property out of the trust pursuant to whatever rules we've laid out. When you initially create a revocable trust, typically that's the same person as the grantor. Because normally if I put my house into a trust that's long term going to plan to provide things for my kids, but while I'm alive, I still want to be able to use my house, right? And so I'm the beneficiary of that trust initially. Um, and so that's then once it gets down to my kids are the ones who are allowed to then either use the house or have the house sold and pull the money out, subject to rules. But they're going to be the beneficiaries at that point in time. And I mean, they can repeat on down multiple generations, and we may end up having multiple people become beneficiaries at different times for different reasons. But ultimately, base level, it's the person who can take stuff out of the trust following the trust rules. So, Kathleen, who's going to run this thing? We said we've got all these rules and we've got the person who created it. We've got the person who's going to get stuff out. Who gets to actually be the guy that signs on the check?
Yes. So that would be the person who runs the trust is the trustee. And in a revocable trust, 99% of the time, the trustee and the grantor are the same person while that person is alive and has capacity. You also will name a successor trustee to take over when you can't. That's one of the reasons why trusts are really helpful for incapacity planning. Because remember our demonstration, you kind of put everything in this box. And then if you become unable to manage the things in the box, you've already got somebody listed ready to go to start managing those assets on your behalf. So that's what a successor trustee is. Successor trustee would also step in when you've passed away and manage those distributions. And you can have more than one trustee. It could be a family member. You can have a corporate trustee, meaning it's a professional business who manages these types of things. And they're in many regards similar to financial advisors, or you think of trust companies at banks. Those types of institutions tend to also have trust companies and are subject to regulations similar to those types of financial institutions. So that's what a trustee is and what they do. And those are the basic characters in the act of a trust, right? You've got the person who makes the trust, you've got the people who benefit from the trust, and the person who runs the trust. And like Eric said before, at the very beginning of the most traditional revocable trust plans, that is all the same person. So if I set this trust up for myself, right, I'm the grantor, I'm the trustee managing it for myself, also the beneficiary during my life. And that's why it's revocable, because I can get in and out and change the things in here however I want. And I just say, hey, instead of saying, hey, this is my car, I own it, I say, I'm the trustee of the trust that owns the car. And this is how we avoid probate most often. So, Eric, we've talked about a lot of different factors here and different questions people have. Before we sign off, is there anything else that you get asked often or pitfalls you see when people bring documents in or anything like that you want to add?
No, I don't think so. I think we've kind of touched on the big ones. Everything else we get into is going to be a lot more, situation specific. That is, and I will say, the one of the things I love about trust is that generally, if somebody asks me, "Can a trust do this?" the answer is yes. Short of asking somebody commit a crime before they get money out of their trust, you can do it. At least in most states. Tennessee, we are blessed to have a very, very broad, easy to amend or easy to tweak trust code that sort of lets us do whatever we really want within our trusts. And so generally, if you can explain to me in clear enough terms that I can understand and put to paper what it is you want to happen, we can do it.
Mhm.
Absolutely. And so that's just it. I feel like they're so flexible, they're so easy to work with and massage into exactly what a specific client might want or need. That just I find that wills just get a little too tight in for me. I like figuring out the puzzle, right? And the will just tells me no, I have to do it this way. I like the trust that lets me do things
Yeah.
differently.
And I think you hit on something important there that I did just want to take a moment to highlight. Because oftentimes I'll have clients come in and they're a little overwhelmed at the prospect of a trust. And I say trusts are challenging and great for the same reason, and that is you can do almost anything with them. And sometimes it can kind of be hard to nail down specifically what it is you're trying to do with your money, particularly when you're looking at generational planning and leaving money to kids and grandchildren. And that's where people like Eric and I come in, right? Because this is what we do all day. So even if you feel like, oh, there's so many things, it's overwhelming, we can say, hey, here's some really basic things that the IRS wants to see. Health education maintenance support, right? We can start there and then we can build from that. We can tell you common ways people do things. And it's not that you need to do it that way, but I have found that if someone is unsure about how to proceed, having some ideas given to them, we could do it this way or we could do it this way, helps them figure out, hey, this hits, this doesn't. Let's look more into this till we can kind of tweak it and get it just right. So, um,
Yeah, I often explain that as right now we're sitting at point A. I'm not asking you to tell me the whole road. I'm asking you to tell me what point B is so then I can lay out for you, here's the three different roads we can use to get to point B.
yes,
And then you can tell me which one you want to do. And then it's really my job to put the pavement on that and make it happen, right? You don't have to worry about that. If your lawyer's looking at you and telling you you need to write out for me what you want your trust, then get a different lawyer. Like, their job is to put down the words to make that happen. Your job is to tell them what you want to have happen.
yes, absolutely. All right, guys. I hope that was helpful for you all. And again, it's our little CYA disclaimer. Remember, this is just legal information and not advice. We hope you found it useful. And next week, we will be talking about irrevocable trusts. So stay tuned for that one. Bye.